My student ID number is 21030253. This is my assignment 1 for video presentation for employment law. So this presentation advises whether Faith Papula has a legal claim against Cherry Tree Garden Center after being denied a position of a manager at a new cafe. So it was a promotion to a manager. Faith has worked for the Garden Center from October 2025 to April 2026. She had a previous management experience as a manager of directors during dining rooms and have received a positive reviews in her current role. However, the promotion was given to Mr. Hossa, a younger single man with a with the less relevant managerial experience. When Faith asked for the feedback, she was told the job was not appropriate for a single mom. The statement immediately raised concern, and she has now asked for the advice. Because this is also a direct contradiction of Equality Act 2010. The key issues are whether the Faith suffered a direct sex discrimination or an indirect sex discrimination because of weekend working requirement, and what remedies she may receive if successful. My advice is that Faith has a strong discrimination claim and a good prospect of success before an employment tribunal. The second slide, I will inform about the applicable legal frame that we have to look into. The main legislation is the Equality Act 2010. Section 11 defines the sex as a protected characteristic. Section 13 prohibits direct discrimination, while Section 19 prohibits indirect discrimination. Section 39 make it unlawful for an employer to discriminate in promotion opportunities and recruitment decisions. Finally, Section 136 regulates the burden of proof in discrimination cases. Faith cannot claim ordinary unfair dismissal because she remains employed. Instead, her claim arises from being denied a promotion because of a discriminatory treatment. The Employment Tribunal has a jurisdiction to hear the claims and can award uncapped compensation if discrimination is established. Therefore, the central legal question is whether the employer decision was influenced by the Faith's sex and the status as a mother rather than her qualifications and experience. Well, first of all, we will talk about the direct sex discrimination. Faith's strongest claim is the direct sex discrimination under Section 13 of Equality Act 2010. Direct discrimination occurs when a person is treated less favorably because of protected characteristics. Here, the evidence strongly suggests that Faith's sex and motherhood influenced the employer's decision. The most important fact is the feedback she received. She was told that the role was not appropriate for a single mom. This statement directly connects the dots of the refusal of the promotion for her because of she being a mother. In Webb versus EMO Air Cargo, the court recognized the discrimination treatment linked to motherhood is closely connected to a sex discrimination. Likewise, James versus Eastleigh, a borough council, confirmed that tribunal focus on the reason for the treatment rather than the employer's motive. And also, we have to look at how these principles are applied. When applying this principle, Faith can argue that she was denied a promotion because the employer assumed that a single mother would not be suitable for the role involving a weekend work. According to the Faith, she has a very strong claim for a direct discrimination. Now, in slide 4, I will ask about the less favorable treatment and the competitor. To establish discrimination, Faith must show that she has been treated less favorably than a suitable competitor. The successful applicant was Mr. Hausa, a young single man, although he has some experience helping in a family takeaway business. Faith has a considerably stronger management experience and a proven employment record as well. In Shamon versus Chief Constable of Royal Ulster Constabulary, the court stated that the tribunal should compare the claimant with the person in similar circumstances who does not possess the protected characteristics. The relevant question is whether a man with the Faith's qualification would have been rejected because he was a parent. Well, the evidence suggested that he would not. Instead, the employer focused specifically on Faith's status as a single mother. Meanwhile, a less experienced candidate received a promotion. Male candidate received a promotion. Therefore, Faith can demonstrate less favorably treated and satisfy an essential element of her discriminatory claim. And number 5 is stereotyping and motherhood. Furtherless, is the employer's resilience on a stereotype employment decisions should be based on an ability or merit, not on a status of that she is being mother or not, and not on the assumptions about the gender's role. However, the employer appears to have assumed that Faith's childcare responsibilities would prevent her performing the roles efficiently. There is no such evidence that Faith was asked whether she could work weekends. There is no particular evidence that her motherhood will be any objection to doing that role. This is particularly significant because a mother lies nearby and could potentially assist with the childcare. In Price Waterhouse versus Hopkins, the court held the decision upon the gender stereotypes are discriminatory. The employer therefore appears to have relied on an assumption that a single mother could not do rather than assessing Faith's actual availability or qualification. This strengthened the Faith's direct discriminatory claims and supports the argument that she was directly discriminated because of her sex. The possible indirect discrimination is also very important to consider here. Faith may have also a secondary claim for indirect discrimination under Section 19. The relevant provision, criteria, or practice is the requirement of the cafe manager must work weekends. Although the requirement applies to all the applicant, women are statistically more likely to have a primary childcare responsibility. In London Underground Limited versus Edward, number 2, the court recognized the working arrangement conflicting with the childcare obligation and may disappropriately disadvantage women. Faith could therefore argue that weekends working requirement places women with young children at a particular disadvantage. However, the employer may justify the requirement because weekends working generates between 65 to 75% of the gardens in turnover. This is likely to be considered a legitimate business aim. For that reason, indirect discrimination is arguable, but whether the direct discrimination claim is a bit weaker than direct discrimination claim. The slight proof is a burden of proof. Faith also benefit from the burden of proof provision in Section 136 of the Equality Act. Initially, she also needs to establish facts suggesting discrimination. Once she does so, therefore, the burden shifted to the employer. In Section 8 of the remedies available, if successful, Faith may obtain several remedies. the tribunal may issue a declaration confirmation of the discrimination occurred, and it may also make recommendations to improve the workplace practices. Most importantly, Faith may receive a compensation for the financial losses. These include lost earning resulting from the missed promotion and may any future losses linked to the reduced career progressions. She may also receive compensation for the injury or the feeling. In Vito versus Chief Constable of the West Yorkshire Police, the court established the guidelines for assessing such award given the humiliation nature of the comment made to the Faith and injury to the feelings